Good afternoon, everybody, and welcome to this joint webinar between the Saudi Center for Commercial Arbitration and ArbDB Chambers. And we're tackling arbitration and mediation in Saudi Arabia and the wider MENA region. My name is Michael Cobra. I'm a member of ArbDB Chambers and a full-time third-party neutral. And it is my privilege to be the moderator for today's session. We have a number of contributors, and then after they have each had their say, we will move to a panel discussion, and we can use the chat facility to make this as interactive as possible. I also should say that we are recording this session, so it will be possible to pick this up from your usual kind of podcast places. We also have a poll facility, and during the course of the webinar, which we will tightly time to an hour, which we will use to ask 3 questions with yes and no answers. So if you use the appropriate buttons, then we will get a view on the questions. I should add that it will not have escaped people to notice that there's a lot going on in the geopolitics and economy of the region, and that may well be something we can focus on in a further session in a few weeks. But we're just going to tackle the subject of arbitration and mediation in Saudi Arabia and the MENA region. So I think that's probably quite enough for me. Actually, I should add that it's my privilege to be a panel arbitrator and mediator on the SCCA panels. So I'd like to start now by introducing Dr. Hamid Merah, who's the CEO of the SCCA. He's had a distinguished career before in the banking and insurance industry and is a recognized leader and expert in the Islamic economy and finance areas. He has both an MSc and a PhD from one of the finest universities in Riyadh, and he's going to kick this webinar off. So perhaps, if I may, I'll hand over to you, Dr. Hamid, and you're very welcome, and thank you for agreeing to participate in this webinar, sir. So over to you.
Thank you very much. Good morning, good afternoon, good evening all around the world. Ladies and gentlemen, it's a great pleasure for me personally and for SCCA to co-organize this webinar today with ArbDB and to speak about this really important topic today. Just to invest the time, I'm trying my best just to be as fast as I can, and I'm gonna present today under the title Saudi Arabia is ADR-Friendly jurisdiction. If you allow me, I would like to share my slides. I hope it's clear now with all of you. Great. Is the slides there? Hello?
Yes, they're there, Dr. Hamid, yeah. Great.
As you may know, for any jurisdiction to be friendly jurisdiction to ADR, there is a lot of aspect and a lot of support needed. But I can summarize that in 3 main categories. First of all, the legislative support, then the governmental support, the judicial support, and these 3 areas will be the first 3 topics I'm going to cover in my presentation. And finally, I will give just very quick background about SCCA, some numbers that might be in interest. If you allow me to start with the first topic about the legislative support, I don't know if a lot of you knows that the arbitration is practiced in Saudi for the last 70 years. But I can say at the same time, 2012 was the golden year. And that year was the first of the change in Saudi in terms of arbitration in particular, and in ADR generally speaking. In that year, the new arbitration law and the enforcement law has been issued, and in the coming slide, I will shed light about some areas to these 2 important laws. And in 2014, the first institutional ADR center in Saudi Arabia has been established by a cabinet decree, i.e. the Saudi Center for Commercial Arbitration has been established at that year. If you allow me to move now just to shed light about some areas related to the new arbitration law and enforcement law in Saudi Arabia, the most important information I have to highlight here is the new Saudi arbitration law is based on Untitled model law, and I think all of you are familiar with the Untitled model law. And if you are familiar with Untitled law, model law, you will know that usually in the Untitled model law and also the laws based on that law include a lot of areas related to the court support, such as appointing arbitrator, interim measure, witnesses subpoena. In addition to that, the enforceable arbitral award. So in the new arbitration law in Saudi, the award is final, it's not appealable, and also very limited time for challenges, 60 days, and with very limited areas. And also it was very clear in the new Saudi arbitration law about the parties' autonomy to select, for example, the applicable law, institutional rules, language, venue, arbitrator without any restrictions in terms of religion, gender, nationality, etc. So just very quickly, these some of the areas related, or I wanted just to highlight about the new arbitration law in Saudi. Again, it was issued in 2012. What about the enforcement law? Also, I think it was very a quantum leap in Saudi Arabia, and for the arbitration in particular. First of all, moving from the administrative, the Board of Grievance, to the enforcement court, specialized court, and also within that court, there is specialized chambers, and with special judges, with the special education and training to deal with the enforcement of the arbitral award in terms of local or international. This, I think, is one of the most important elements. And also empowering the enforcement of the arbitral award and make it easy, straightforward, effective, and that has been translated into numbers that I will share with you in the coming slides. And also one of the things that I would like to highlight, considering the arbitral award as enforcement title or executive bonds as some translation. So these areas just will show an example of the importance of the new arbitration law and enforcement law. After that, in 2019, another resolution has been issued by the Council of Ministers to approve SCCA statute. And I think there is a lot of details related to that, but what I want to highlight in a few seconds, it has been, this new statute supported the independence of SCCA, the independence of SCCA from the government. So SCCA is not related, not reported, not part of any governmental entities. And one of the examples of that, it was a condition, it is a condition for all the chairman of the board and also all the members to be not from the government. And we witnessed some example, for example, the current Minister of Finance, he used to be the first chairman of SCCA board. As soon as he was appointed in governmental position, he left SCCA and also the current Minister of Housing, the current some other ministers, they were in the first and second term, and as soon as they were appointed in governmental position, then they left SCCA to make SCCA independent from the government and at the same time independent from the private sector. And also the statute of SCCA mentioned clearly it's not for profit organization, and also empowering the board, so the ultimate authority of SCCA if it's board. And also I would like to mention there is no restriction of appointing Saudi or non-Saudi. There is no restriction in terms of nationality, again, gender, religion, to be part or to be a member of the SCCA board. The only restriction, none of the board member and the chairman has they can be a governmental figure. Also in 2019, I don't know, a lot of experts, they know if they are interested in Saudi and they know laws and regulations in Saudi, the governmental agencies for decades, they were banned from settling their dispute through arbitration unless they grant a special approval from the cabinet. In 2019, in January 2019, Royal Decree has been issued to encourage governmental agencies and state-owned companies to settle their disputes, especially with foreign investors, through arbitration. And few months after that, in August 2019, the new Saudi government tender and procurement law has been issued. And the quantum leap in that law, in article number 92, let me read the exact words of that article. The government authority, after seeking and securing approval of the Minister of Finance, may agree to arbitration as indicated by the implementing regulations. And also the implementing regulation, as you can see in article number 154, it gives a lot of details to that and make it straightforward, easy, and you will see in coming slides another step further to support ADR and arbitration, in particular in the governmental contract. And as you can see, the quote from the Minister of Finance himself when he was speaking in SCCA International Conference in 2018, he mentioned clearly that this law and the implementing regulation is supporting the governmental agencies to use arbitration and in settling their dispute. And you will see a further step has been taken by the Ministry of Finance and the Minister of Finance himself. Again, in the same year, in 2019, in the fourth quarter, the new franchise law has been issued and also is supporting arbitration, mediation, ADR in general. And also, as you can see, the exact wording of the article number 25, it's permissible for to agree to settle dispute that arise from the franchise agreement or the application of this law by alternative dispute resolution such as arbitration, mediation, and conciliation. A lot of example, I counted more than 6 laws and regulations and royal decrees has been issued in 2019 only. All of that laws and regulations and royal decrees with the same rhythm to support ADR and institution arbitration in particular. Let me move very quickly because I would like to invest the time to the governmental support. There is a lot of examples. I will not be able because of the time to cover all of that examples, but just let me just choose 1 or 2 examples. The first example is the Ministry of Commerce. They have in their website what they call it model contracts in different areas, such as establishing a company, a joint stock company, a lot of model contracts. They change a lot of that contract, the model clause in that contract to SCCA model clause. So this is one of the examples. Different example, you can see it, and also later we can give you a copy of this presentation. Let me now go to the most important example that I would like to mention. Just few weeks after the implementing regulations, the Minister of Finance he authorized the circulation of 14 standard government contracts. That all of these contracts, all of these unified contract for the government, all of that contract, SCCA model clause is the default and the default clause in that contract. Yes, the parties, they can agree on any other institution, but it's a great, it's a great achievement to make the model clause in all of these governmental contracts the SCCA model clause. Another example, maybe my colleagues today will cover something related to that. I think one of the most important, change and milestone in ADR industry globally is the Singapore Convention. We are proud that Saudi is one of the founding signatories for Singapore Convention. Saudi signed the convention in last August in Singapore, and also Saudi is the 4th country to ratify the convention, and I think there is a lot of implication related to that. And this only, it's an indicator from the Saudi government about the support of ADR, and there is a lot of examples, but because of the time, I will stop here. Let me go very quickly to cover the third topic about the judicial support. That could be illustrated in 2 main areas, the enforcement, and that will come in the coming slide. And here's some examples. For example, referring mediation cases from the commercial court to SCCA to be settled and managed under SCCA rules. Also, the commercial court law states, has been issued just a few weeks ago, state for mandatory referrals of cases to mediation and conciliation. Another example, SCCA nominate arbitrator to the appeal court, for example, in Riyadh for ad hoc cases. A lot of examples. For example, also SCCA developed and conducted some workshops with the related judges in the enforcement court and also in the appeal court. In that workshops, we gathered international judges and international experts to meet the Saudi judges, and they discussed about the, the new and the latest practices in that regard. Finally, one of the things I'm proud of, I'm happy with, that the Ministry of Justice, they are announcing from time to time numbers related to enforcement, especially about the enforcement of the foreign arbitral awards. And as you can see here, some examples. This is just I choose randomly some of the example about. Sometimes the Ministry of Justice, they choose some big cases and they specify cases from different countries all around the world, ad hoc or institutional, and they mention some details related to that. Sometimes they mention institutions, sometimes they mention the country. But I encourage all of you, if you are interested about the Saudi market, just to follow the official website of the Ministry of Justice to follow up some numbers related to the enforcement of the arbitral awards. Finally, I don't want to take more time, just I will shed light in few minutes about SCCA. SCCA, as I mentioned, is the first institutional ADR center in Saudi. We are independent, we are international center, we are international in terms of our staff, in terms of our roster, in terms of our cases, and you will see examples. SCCA only less than 4 years old center, and we are proud to say a 4 years old center or less than 4 years old center. We could register 91 cases in terms, and these cases arbitration, mediation, limited services. And as you can say, we are international, so the parties of these cases, not Saudi parties, Saudis, and also parties from, as you can see the flags here, from the US, from UK, Germany, France, China, different countries all around the world. In addition to that, the diversity, not only about, the type of cases, not only about the parties, nationalities, also the industries. The biggest part of our cases was construction, and we know how important construction for MENA region and GCC countries in particular. But you can see a variety of industries such as banking, capital market, medical, entertainment, aviation. All of these industries, only in 4 years, we could register 91 cases distributed among all of these industries. Our roster. Today we have the speakers. We are proud to have some of them in our roster. As you can see, the number more than 280 arbitrators and mediators. More than two-thirds of them non-Saudis, or around two-thirds of them non-Saudis. They are from 23 nationalities in more than 15 fields, such as oil and gas, energy, banking, Islamic banking, a lot of industries. And also they are speaking more than 11 languages. Again, I would like to move to another aspect. As I mentioned, we are international. We are trying from day one to be within the best practices globally. Because of that, we, around a year ago, SCCA launched its advisory committee. And as you can see, rock stars from all around the world, 14 experts, some of them judges, professors, well-known arbitrators. They are from 11 countries all around the world, Saudis. For example, we have Judge Abdulaziz as a judge, Saudi judge, and also we have well-known lawyer, Dr. Fahd Abu Hamid. He is a partner with Clifford Chance. And we have well-known lawyers. They are advising SCCA. And for example, now we started since last October to review our arbitration rules, and they have started to support us. And also they supported us also in the EMP. I will talk about it later, but this is one of the things to show you the vision of SCCA and the standard of SCCA. Again, also just a few weeks ago, we announced officially the establishment of the SCCA Committee for Administrative Decisions. And as you can see clearly, their role is, it's like a mini court in SCCA, 3 well-known figures, and all of them, as you can notice, they used to work in well-known international ADR centers, Cairo Center and ICC, and also AAA ICDR. Now they are in the SCCA Committee for Administrative Decision. Their role mainly to take decision about the challenges related arbitrated challenges, dispute concerning place of arbitration, and number of arbitrators. I don't want, I know that I talk more than I'm supposed to take, but finally, SCCA, within a few weeks, we announced new program to deal with the pandemic. We know the disruption has been, the industry and all around the world is facing after the pandemic. So we announced what we called it COVID-19 Emergency Mediation Program, EMP. And this in brief is we had, you can say discounted fee schedule for the EMP, and also it's virtual 100%. In addition to that, the most important element, the settlement after if the parties will reach a settlement after the mediation, in coordination with the Ministry of Justice and Conciliation Center, this settlement could be converted into enforcement bond, and I think this will illustrate or translate the spirit of Singapore Convention into institutional level and also in local level. A lot of details. We have a dedicated website about the EMP, a lot of materials, legal material, marketing material, and also some materials for awareness in different ways, like infographics, motion graphs, videos, a lot of good materials. I encourage all of you to visit the EMP special page or special website. I will stop here by thanking all of you, and if there is questions, I will be more than happy to discuss and to cover during the discussion time. Thank you again.
Thank you, Dr. Hamid. A great tour de force, and actually, I don't think you've overshot on time at all. That was perfect and really set the scene very well. Okay, well, we'll now move on to bring in Robert Sliwinski. Robert Sliwinski is a quantity surveyor and barrister, and he's a colleague of mine, a colleague of ours in ArbDB Chambers. He's a fellow of the Chartered Institute of Arbitrators and a chartered arbitrator. He's also on the FIDIC President's panel of President's list of international adjudicators, so involved with dispute boards, and he's experienced in construction and other areas, and he accepts appointment as arbitrator, mediator, adjudicator, expert, determinant, and DB member. And he's going to talk about the dispute scene in the region, and also some stuff about family business disputes, and perhaps touch on dispute boards. So Robert, the floor is yours.
Oh, thank you very much. Yes, and thank you. It's actually a privilege and honour to be asked to talk in this webinar. I am actually on the roll of the SCCA as well, which is also a great honour. And I work out of a law office, Al Suwaidi, in Dubai. And I've been here for the last 2.5 years or so, so I'm beginning to get some idea of the dispute process within the GCC region. So what I thought I'd do is just talk through some of the issues as I see them within the GCC region. What is clear to me is that dispute resolution is multifaceted. When you take into account the interlaced jurisdictions that we have in the GCC region and the significant number of family-owned businesses. Now, I find this slightly unusual to what I have found in the West, if I can put it that way, where family-owned businesses take up approximately 60% of the GDP of the area, and it employs something like 80% of the workforce. So it's actually a very powerful part of the economy in the GCC. When I say family-run businesses, of course, I don't just mean small family-run businesses of 6 people or so, but it encompasses family-run businesses that employ thousands of people. And this is reflective of the businesses within the region. Why is it multifaceted? Well, of course, the GCC is predominantly a civil law jurisdiction. I say predominantly because certainly here in the UAE, we have the DIFC courts and the ADGM courts, Abu Dhabi, where common law is the jurisdiction. So we have a mix, civil law and common law. And this is quite important because it allows, certainly in the DIFC and ADGM areas, a choice of jurisdiction in your contracts. And of course, a choice of venue for having your disputes dealt with. You may prefer the common law procedure. There may be reasons why the adoption of the common law jurisdictions and laws are preferable to the on land, if I can put it that way, jurisdictions of Dubai, Abu Dhabi, Saudi, and other areas. You do need to make sure, of course, that wherever you're contracting, you can in fact make that choice if that's available to you. Certainly it is in the UAE. Why would you want to make that choice? Well, of course, that's down to the type of work you may be carrying out, the people you're contracting with. Maybe it's international, maybe it's domestic. Are you actually based in the DIFC area or the ADGM area? That may actually mean that you actually have to be within those jurisdictions. But moving on, the dispute resolution arena within the GCC region has actually been building, I would say, for some time. As Dr. Hamid has made quite clear, the Saudi ADR practices and certainly the SCCA is relatively young, but they are moving at pace. It's quite clear that the judiciary in Saudi supports arbitration and mediation, and that's very healthy, it seems to me. And the judiciary have come to recognize within the GCC region, and by that I'm including Bahrain, as well as the UAE and Qatar, that arbitration and mediation, perhaps to a lesser extent, is an important way to resolve disputes. And it takes the pressure off the court system as well. Yes, we are talking about perhaps initially the more technical based types of disputes, such as my own area of construction and engineering, but it can go much further than that. You find in the GCC region that family disputes, labour disputes, and not only are dealt with within the court system, but also there is ADR is also used in trying to resolve those disputes. And again, to me, that seems to be a healthy and sensible way forward. However, certainly labour disputes still tend to be dealt with by the courts, but it's interesting that the specialist courts, and certainly again in the UAE, we have something called the Rental Disputes Settlement Centre to deal with landlord and tenant disputes. And that is again, utilising a form of ADR, that's actually a form of mediation, before you get involved in litigation itself. And again, that's much better for the parties and helps resolve matters without a long drawn out litigious process. So I can only say that from my own experience, that ADR in the region is certainly moving forward at some pace. It's certainly being supported by the court system. The court system itself is recognizing that it needs specializations, be that onshore in Dubai or Abu Dhabi, for example, or within the free zones such as the DIFC and the ADGM. Well, certain issues remain, without a doubt. Jurisdictional challenges are constantly seen within the GCC region, and it seems to me that respondents, defendants use such jurisdictional challenges to try and delay matters and try and drag the inevitable out, perhaps. One of the ones that's common here, but less common in the UK where I'm from, in fact, I say less common, it's not seen in the UK at all, is the sort of jurisdictional challenge about, was the person who entered into the arbitration agreement authorised to do so? You may have been authorised to enter into the contract, but were you specifically authorised to enter into arbitration agreements? You have to have a specific authority to do so, be it within the memorandum of association of the company or by some sort of board resolution. And that's something which is not normally seen, certainly in the West. Those sorts of jurisdictional challenges, seems to me, are unhelpful. Are they really necessary? It's not a matter for me to tell the governments here their business, but it does seem to me that that's something that should be looked at. Are those types of challenge sensible, helpful, and necessary within the region? So, moving on into slightly more specific, in my area, construction, infrastructure, engineering, we've had disputes, many disputes over the last decades, because of course construction and engineering have been a predominant area of business and work within the area. It's been expanding to a very large extent, and indeed, despite the economic problems that we face in the GCC region, and indeed have since 2008, I guess, there's still a lot of work going on. There's still a lot of money being spent within these regions, and we're still expanding. Business is still expanding, therefore construction and infrastructure expands as well. However, turning away from dispute resolution itself just for a moment, one of the reasons for many of these disputes, it does seem to me that a lot of it comes down to the contracts that are used in the region. We're still using old versions of standard contracts. For example, the FIDIC contract. I see many contracts based on the pre-1999 suite of contracts, let alone 2017. So we really ought to be encouraging the parties to use more up-to-date contracts, be more contractually aware. Many disputes, of course, revolve inevitably about non-payment. And here, unlike again the UK, pay when paid clauses are perfectly legitimate. That's okay. But when you're entering into a contract, certainly as a subcontractor, are you aware that's sitting in your contract? Are you aware of the repercussions of if the employer doesn't pay the contractor, you won't be paid? Should the subcontractor take the burden of the project in financing the project when he's perhaps the least able to do so? These are matters I feel that could be looked at to try and help avoid disputes in the first place. Dispute avoidance is something we should be considering. It shouldn't be just all about arbitration at the end of the project. By then the damage has occurred. We ought to be trying to really help the parties to avoid the disputes in the first place. Yes, of course, disputes will occur in any event. This is also clear where you see a larger level of smaller companies entering into the arena. Some of the very big international construction engineering companies have pulled back from the region, allowing smaller, medium-sized companies to come in. But are they aware of the risks? Are they aware of the contractual risks that they're undertaking by working in these regions with the laws and the contracts as are presented to them? They need to be, is educated the right word, but more aware anyway of their rights, and perhaps that they should be negotiating with a bit more strength with the contractors and the employers, especially if their specialization is something that's needed and is perhaps not readily available from another source.
Robert, could I give you maybe just a minute or two, and then we'll move on to James?
Am I rattling on a bit there?
No, that's all right. Carry on.
Thank you. Okay, so these matters need to be dealt with. I did say I deal with family-run businesses a little bit as well. As mentioned earlier, They are a very large part of the economy here. And the disputes in family businesses, we're looking in the business itself rather than disputes with other companies. Because of course, it's not just about money, progress, so on and so forth. Issues of status, pride, succession, overreach within family businesses. It overreaches the issues of profit, control and management. It becomes a matter of members of the family feeling they should be more involved in the business or feel they're being cut out of the business as it evolves, changes, succession occurs. We need sensitive dispute resolution to deal with these matters. These don't need the blunderbuss of arbitration. This is where mediation and conciliation, it seems to me, come to the fore and should be used. So we need to try and promote mediation and conciliation to family businesses as a way of dealing with their internal problems. It's very difficult for families to open up to an individual, an outside individual, but that may be the best way of resolving their issues. And it's not about winner taking all either with family businesses. It's finding a way of them settling whatever their issues are, moving forward and being successful. Other areas of ADR that we should be looking at, neutral evaluation, mediation, conciliation, of course, dispute boards, which is obviously something that's close to my heart, which involves a large sector of dispute avoidance that we shouldn't be getting to having to deal with adjudication within dispute boards, but we should be working with the parties to resolve the differences before they blow up into a dispute. So, Michael, I hope that brings me neatly to the end of my time, and I'd be happy to rattle on in much more detail, but to any questions, we'll be there at the end. Thank you very much.
Okay, thank you, Robert. And we've got 2 polls so far. I'll give the result of the first one. The question was, do you expect an increase in ADR in GCC in 2021? 98% said yes, so that's very encouraging for all that we're talking about today. So James, may I bring in James Macpherson? Now James, and I keep on misspelling his name, which is very unfortunate. He's James Macpherson with an MAC, and he's an international expert in ADR. He's special counsel at the Saudi Center for Commercial Arbitration. He works internationally as an ADR specialist and is a veteran mediator. And he's a deep knowledge of the region. He was the inaugural CEO of the Bahrain Chamber of Dispute Resolution, and also an inaugural member of the board of the Oman Arbitration Center. And he's been working in the region, across the region, MENA, since 2008. So we're delighted to be welcoming James. So over to you. So I guess you've got about 12 minutes or so.
Brilliant. How are we doing on that slide? And does it advance when I press advance?
It does, yes.
Excellent. Thank you so much. And greetings to all of our colleagues around the world. Obviously, Dr. Hamid's outlined how much Saudi Arabia has been transformed since the setup and development and the ongoing progressively impressive work of the Saudi Center for Commercial Arbitration. And then, of course, we heard from our brother Robert in Dubai, and we all know that what's been going on in Dubai has also been very substantial and impressive with the uptake of all sorts of ADR. But I want to talk about how this has impacted the region and how it is actually helping people to navigate the whole COVID era. Briefly, I'm going to touch on ADR globally, the legal profession, and then speak about 3 elements within the region, specifically arbitration, ADR centers, and mediation. Because as Robert said, it's definitely something that has great scope and applicability for those that we all serve in the region. Right now, what we're dealing with, there was a GAR live event very recently in which an Australian and Singapore practitioner made this comment: the appetite to pursue disputes these times seems as great as ever, but parties were investigating their prospects for successful enforcement more fully before commencing arbitration. During any particular transition economically, there's always a push for managing disputes, but I think this particular challenge has been excessively novel and has been very hard for people to predict how and when it's going to play out. But I think that within this, ADR is going to be particularly important. And specifically, a lot of the people on this call are legal practitioners or those dealing with managing litigation and risk. And an interesting observation has been made in the UK and in other jurisdictions, and this example is the Canadian one, that after a lengthy disruption of activities, this could also compromise the financial circumstances of the applicants, which was alluded to in my previous slide, but also the viability of law firms themselves. And this includes smaller firms and sole practitioners, which any of you who worked in the region, and most of you have, know there are a lot of small and medium-sized firms out there. So they're going to have real challenges dealing with their clients, adding value, and finding the right way to engage them and to advise them. But there's also the question, which is of concern, not just to those concerned about the legal profession and the commercial sector, but also consumers and others having access to justice. And if this continues unabated, this will undermine the, this is the courts that this is specifically referring to, but it's also equally applicable to those accessing it through ADR institutions and even the ad hoc, is you're going to have increasing access to justice issues coming up. Now, obviously, the virtual arbitration option is going to be the game changer. It is the game changer because it has so many efficiencies. And as we've all commented elsewhere, there's increasingly going to be people who are saying that they are not interested in going all the way back to full face-to-face, start-to-finish procedures, whether it's arbitration or mediation. I think we can all acknowledge that now that this has been rolled out so effectively across the world, this is here to stay. And the good news is that this can actually help people in terms of how they do deal with parties locally and internationally. And I think it's a two-way street. I think you'll see practitioners from the region offering their services internationally and internationals offering their services regionally. But it will also help in terms of procedural timelines and just handling costs generally. Now, there are issues about using video conferencing for arbitration. And one of the many comments that and analyses offered recently, for example, is by an American-based National Academy of Arbitrators. There's always this question about, for example, you have this need to provide a fair and adequate hearing and to provide effective services to parties, but how would you allow an arbitrator to issue an order without mutual consent? And I think that given the extraordinary nature of what we're dealing with, and this is what the NAA has asserted, is that you can, that the hearings during an extraordinary incident such as this, and if there's a party in opposition is non-responsive, declines to provide reasonable explanation, and or the case involves continuing liability or time-sensitive matters, they can proceed. The good news is for our region is that, I'm not sure, there we go. What have we got in the region? The region actually, sorry, I wanted to just do that. I double-clicked by mistake. Virtual arbitration does work in the region for several reasons, including, and these are some examples, it is addressed in things like the Saudi arbitration law. It is addressed in the UAE federal arbitration law. And the institutions, all of them, including the Cairo Center listed there, they all provide for the use of the technologies to allow parties to avail themselves of this, and that these things will be admissible, acceptable, and otherwise. So this is part of the existing legal framework in the region. The procedural rules and so on accommodate the use of virtual ADR. So this is very important for anyone in the region or anyone coming to the region. Just very briefly, I wanted to show you, because since I came to the region in 2008, we've had literally a sea change. Every single member state of the GCC, and in fact, most MENA nations have an ongoing concern, an ongoing ADR Center initiative. And for the balance, they've done quite well. And you can see that if you look across the region, most of them offer arbitration and mediation, case management. They offer the facilities, which inshallah we'll all be visiting sooner rather than later. But in the interim, virtual mediation has been rolled out pretty much across the board and with reasonably good results in terms of delivering the services. The latest on the far side is Muscat, and they will next year be joining the fray. But it's not just about arbitration, as both speakers have noted. We've got to consider mediation. Now, why is mediation taking root in the region? In part because there are court-connected programs. Saudi Arabia has court-connected programs. Dr. Hamid's been working, and our team has been working with the Ministry of Justice, with the courts, but also they've gone further and they've engaged the Ministry of Commerce and others. So there are a lot of court-connected or agency-based mediation initiatives, which are having a big impact on how mediation is perceived. Similarly, they have court-connected mediation in Saudi Arabia through the Ministry of Justice there, and we've been training mediators recently on that. Similarly, UAE courts have committees for mediation which cover the spectrum of disputes. DIFC and ADGM, both their court systems offer mediation programs at present. So I think you can see that the infrastructure is there, the capacity is there, but also the reason mediation is having impressive results is this long-standing effort by a lot of players across the region for many years in terms of sustaining these programs and trying to get the results and success stories out there. One of them is just the transformation and the elevation of regional talent. I don't think most people know that thousands of Arab lawyers and professionals have had skills development and training through the Chartered Institute, the Saudi Center for Commercial Arbitration, the Bahrainis, and elsewhere. So we have been training literally thousands of Arab lawyers and other professionals in mediation skills, in mediation awareness, and other workshops. But also driving it are the ad hoc cases, which have always been in the region. I've done ad hocs in Saudi, Bahrain, and elsewhere, and I can tell you that the parties are very sophisticated and very amenable and capable, and they do resolve their disputes. Again, longer term, they've had success with programs in Jordan, Saudi, Bahrain, and elsewhere that are court connected. And as I said, the agencies in Saudi. The other thing is that the private sector is driving this. And just so you know, it's not just when, for example, Dr. Hamid and I are in Washington meeting with Raytheon, Northrop Grumman, or some large players, or in London meeting with others. When we are doing all of our outreach to whether it's oil and gas, energy, or other players, there is this awareness and this willingness and this use by multinationals, regional players, and people with working in and from the GCC and the MENA region. So increasingly, people are putting in step clauses into their contracts. Ad hocs continue, as do post-dispute referrals to the institutions. Now, I think COVID is going to be driving existing, but also new users into the use of mediation. Now, the neutrals themselves, I can say, are themselves promoting the services directly to their peers and also promoting those to the corporations. And that's hugely important. The outreach that people like Dr. Hamid, myself, and others have done over the years, as well as Michael, John, and Robert, and as I say, a lot of the institutional players, is going out, meeting with, and briefing not just the law firms themselves, who are quite sophisticated, but the corporations. But I think you're going to see that the imperatives of access to justice are going to be driving this as well. And as tides float all boats, arbitration will benefit as well as people use mediation and move forward. The legal profession has clients who are coming to them having experienced mediation either in London, New York, Paris, elsewhere, but also Singapore, Riyadh, Bahrain. So people are doing that. To give you a sense of how deep the roots are for ADR, you have to understand that the legal practitioners are also donating a great deal of their time to ADR competitions, moot competitions, which are ongoing in the region in Arabic and English. You also have to consider the supportive legislative environment. So even the Saudi commercial law that came out, it also encourages early dialogue and early settlement of disputes. And it expressly permits the commercial courts to utilize mediation in the private sector. So ADR is named as an option, as something to be tapped into and promoted. And an interesting comment here by Clyde & Co., where they make the comment, we'll make ADR mandatory in some cases. They say, while mandatory mediation is a patchy record and success in other jurisdictions, any initiative by the commercial courts to encourage ADR is to be welcomed. And for too long, litigation has been the sole port of call. Making mediation mandatory in some cases may serve to raise awareness of ADR in the kingdom and reduce the amount of unnecessary litigation. I've always found, whether it's in Canada, the United States, UK, Europe, Australia, Chile, doesn't matter where it is, mandatory schemes have primed the pump, increased awareness, and provided legitimacy, even cover for those pitching it within their organizations. Also, you've got to consider that increasingly there are mediation laws being put in place across the region. Saudi Arabia Bahrain last fall introduced their mediation law. And what's interesting about it is it has created a Ministry of Justice certified mediators list, but the flexibility, they're always mindful of party autonomy. Our parties are allowed to retain external mediators if they agree to do so. But what's important also is that they impose things like ethical standards. And they also, it's important that these local statutes are there because there have to be certain things that you won't find in other jurisdictions. In red, you'll see in the middle of the page, not serve as a mediator if he or she and one of the parties have kinship to the fourth level. These things matter and are relevant to a place like Bahrain, where the number of people involved may have to be reflected upon, and it's a fairly limited pool in some instances, but it is growing. But finally, I think what's important is these issues like confidentiality that in the past have undermined the effectiveness or appeal of mediation in the region have been addressed. So all mediation proceedings are considered confidential unless the parties agree otherwise. And the courts may refer them, and the agreement is enforceable by law. Saudi Arabia has a mediation law that is in the final stages as well, and Dr. Hamid is elbows in on this, as we all are, and working to try to see this law in mediation. And this is relevant for a number of reasons, including the fact that Saudi Arabia ratified the Singapore Convention. So they're going to have to be getting in line, so to speak. But as White and Case noted, international settlement agreements falling under the convention involving local assets may be enforced directly by the courts of Saudi Arabia. So White and Case says that you can proceed with confidence. Similarly, Al-Tamimi made the note that mediated settlement agreements agreed in the kingdom can also be invoked and enforced in other signatory states. So I think this is producing a great deal of confidence for those wanting to use it. So overall, and just to conclude, I just wanted to make the point that successful jurisdictions and centers will likely continue growing. The caseloads are growing. They have the track record with the staff, the rules, the procedures, and of course the case law that was alluded to by Dr. Hamid. And we, by the way, have articles that we've written with GAR, among other publications, specifically addressing the issues of the case law and issues like diversity, because I think it's really important for people outside the region to know that what we're dealing with is a region that is really embracing gender, professional, geographic, regional, sectoral diversity completely. So that among those thousands of lawyers who have been briefed, trained, and engaged in things like being certified as fellows of the Chartered Institute of Arbitrators, as arbitrators, or as court-certified mediators in Bahrain or mediators in Saudi, Kuwait, Oman, and elsewhere, what you're going to see is, because of this, there is a level of sophistication that is driving all of this: the judiciary, the lawyers, the practitioners. And because they have this comprehensive suite of virtual ADR services, they're able to provide this for whatever the duration is of this COVID challenge. So finally, the factors that will determine and drive the greater innovation uptake of ADR: ad hoc versus institutional, regional versus international, local access to justice, managing risk, the increasingly impressive, as opposed to the past, judicial appointment performance in Saudi, in Bahrain, and in neighboring jurisdictions. The UAE is coming along as well, and Oman, the quality of the neutrals, and the ongoing reform and enhancement of legislative frameworks. So it's very impressive stuff, and I thank you.
Thank you, James, and thank you for keeping to time. We have the result of the second poll. I don't think I've given that one. Are you optimistic about ADR in the region? 97% say yes. We also have the result of the third poll, which was, will London continue to be a preeminent place for references for arbitration for the region? And that came up with a 61% yes answer. So from our fantastic audience, we have had a couple of questions, which is good. And indeed, from our colleague Tony Marks, he says, what is the panel's experience of the use of adjudication in the GCC? And from Alistair Gray, he's asked a similar point: statutory adjudication, would it help in the Kingdom of Saudi Arabia in transparency and fairness in construction? So I'd like to bring in John Wright, our colleague from ArbDB Chambers, also on the panels of the SCCA and a chartered arbitrator, past chair of the Chartered Institute Board of Trustees, FIDIC President's List Adjudicator. So, John, I'm going to put you in the hot seat and just ask you what you what would be your view be of the introduction of statutory adjudication in the various jurisdictions in the region, and then maybe pass on to Robert. So just very briefly, John, over to you.
Thank you, Michael. Well, these are obviously personal views and not ArbDB Chamber's views. Robert, we have a different view. Adjudication has been very successful in the UK, but it's had, as Dr. Hamid said, it has to have all these systems have to have enforcement. They have to have support from the legislation, from the courts, and so on. Now, that's been true in the UK. If it is true in other countries, then I think adjudication could work. Where you're going to get resistance is obviously from employers who will say that just ends up with me having to pay earlier. What I might want to put forward is something you, Michael, referred to in your introduction, which is the use of dispute boards. Now, I've been to a 3-day conference on dispute boards, and in 2 minutes, I'm not going to explain what they are, but they're broadly, for those in the audience who don't know, it's broadly one person or 3, sometimes 5, who will be involved in a project from the outset. And their role is not simply to sit as adjudicators and determine disputes, but also to assist the parties. And in fact, only yesterday, I was discussing a potential project, not in the GCC, but not too far away, with someone. And he said the reason we wanted to establish a dispute board is, yes, to determine some issues, but actually to bring the parties together. The job of this dispute board, it'll be a 3-person one, is to try and stop the parties arguing and to bring them closer together and to try and find some harmony. And that was the driving factor. And whether I'll be involved in that matter, in that particular project, remains to be seen. I'm obviously one of 2 or 3 who are being considered. But I thought that was a very interesting observation. And that gives, I think, dispute boards a wider attraction and appeal than adjudication can ever have. Adjudication is rough and ready, it is fast, it is quick, it is effective, and if it is enforceable, and it always should be, then it can keep the cash flow moving, and that was the purpose of introducing it in the UK and around the old Commonwealth, Australia, New Zealand, and so on. Dispute boards have a similar remit, but they do have this wider appeal, which I think if someone was saying, would you like to introduce statutory adjudication or to have a robust system of dispute boards, I would go for the latter. I was involved, and I'll be very brief now, I was involved in what I was told, and other people may say this is wrong, but simply what I was told was the only dispute board at that time in Saudi last year. And we issued a decision. And of course, then the dispute board simply is functus officio. We have no further role to play on that particular aspect. We don't know if that was enforced or not, but it was a fairly swift process. It was a great deal cheaper than arbitration. It dealt with a particular issue between the parties. We weren't able to facilitate any sort of settlement, and that wasn't our role in that particular issue. Had we been there right from the start of the project, maybe we could have had a broader role of dispute avoidance. I think dispute boards in construction projects, tech projects, shipbuilding projects are the future. And I think that's where people should be going. Adjudication, yes, but DABs, DAABs, I think definitely yes.
Okay, just very quickly, Robert, is there anything you'd like to add?
Yeah, I would agree actually with what John has just been saying. But as far as adjudication is concerned, unless you have judicial and statutory support, it's not going to work. So it comes from essentially from government down. Adjudication will work, and it's certainly useful for perhaps the smaller projects where dispute boards will be considered over the top, uneconomic perhaps. But dispute boards, without a doubt, do work. They have they're multifunctional in dispute avoidance as well as resolution if that's necessary. And even here in Dubai, I've been approached for a couple of dispute boards. Admittedly, they're to do with the Expo, which is now 2021, of course, and the pavilions. Maybe it's international outside forces that wish to use dispute boards there. As far as adjudication is concerned, I've been approached for adjudication here, but it tends not to go ahead. It's difficult for adjudication to get off the ground, although a few have actually been agreed between the parties and the system has been used.
Thank you, Robert. And thank you to Alistair Gray and Tony Mutz for their questions and points. So perhaps one for you, Dr. Hamid, from Michael Patchett-Joyce, who some of us know well. What plans does the SCCA have for dealing with ADR in the various free zones that are being established in the kingdom? Over to you, Dr. Hamid.
Thank you again. I think this is a really important question because, for example, currently we have a representative office in King Abdullah Economic City. And also a few weeks ago, we celebrated our office in King Salman City for Energy, so what it called Spark. In addition to that, we have very strong and a relationship with King Abdullah Economic City also. King Abdullah Financial District. So all in all, and also there is some kind of cooperation with between SCCA and the special authority now. They are managing and supervising the free zones and the economical cities. SCCA, I can summarize my answer. First of all, physically, we are already there in some of these cities and free zones. Number two, we are ready in terms of our roster. As you saw, our roster is well diversified in terms of nationalities, civil law, and diversity in all aspects. Number three, also there is a lot of steps has been taken in cooperation with these cities to be there physically, and also now the online application is helping us. So what I can assure, yes, we are ready, and we are already in contact with these free zones, and we started to be there physically in some of it, and soon we'll be in some other. If you allow me, also another question has been raised to ask about the online application. If you allow me to answer that, because it's very related to that. One of the attendees asked about the MENA region, which institution they have. He called this call it electronic application. What I can assure, even before the pandemic, SCCA launched its ADR online dispute resolution for the small cases. It's virtually 100%, and that's away before the pandemic. So we were preparing ourselves for that even before the pandemic. So it's 100%, not only the application is online, the whole process from A to Z is virtual and online. In addition to that, also maybe the second week in the pandemic, we announced the application of arbitration and mediation cases is online, and until now it's online. So anyone can apply for arbitration and mediation cases online in SCCA. In addition to that, the special program that we launched during the pandemic, we called the EMP, also it's 100% virtual. So what I can summarize, we were ready before the pandemic, and the pandemic make us more familiar, more supporting, and if all the parties now they are okay with the virtual hearings, virtual application, online applications. So all in all, yes, we are already we are having the electronic application.
Okay, that's a great question, a great answer, Dr. Hamid. And now I have a question from my former colleague Sarah Anticoni, and this is probably one for James. What do you think the primary drivers are for mediation in the region? Now, bear in mind, Sarah's a family lawyer and family mediator, so she's probably interested in family and family business disputes, but not necessarily exclusively. So is it privacy, cost, or speed, or all three? James, what do you think about that in a regional context? And maybe Dr. Hamid as well. But go first, James.
For the National, the newspaper in Dubai, it's probably now almost 10 years old. They the embrace by family businesses that was alluded to by Robert is there. I've done a number of them. My colleagues do a number of them, and a lot of these home office centers, initiatives, and councils and associations across the region have been assisting in bringing in all of us to speak to their memberships, to speak to their leaderships, and to spread the message. The reason they're interested in part historically was privacy. All the mediations that I did in the MENA, even when they were family-run businesses and or had an element of let's say, complex family issues chose to actually hold these mediations in London, in Germany, at Paris, and overseas. They were not held in the region. I think that was because there were a lot of people involved in any given one of these, and they didn't want to be seen to be assembling at the local hotel or suite of services, because it would signal to everyone in the community that something was afoot or awry. So I think historically, privacy, secrecy, confidentiality, social issues were preeminent. But over the last 5 years, increasingly these mediations and arbitrations are taking place in the GCC. And I think that speaks to an evolution of how people perceive things like mediation. So I think people are embracing it in part because they see it as not being, they see it as being a constructive process. They see it as working, and they are moving, how would you say, further and further upstream. So they're not letting them linger, because initially they were old disputes that had festered. Now people are bringing us in because they see a problem percolating. So its timeliness is increasingly there, but I think it's also confidence in the process. And by the way, family mediation is something in the region and has something that I would be happy to talk to her about.
Okay, well, that's Sarah Anticoni from Charles Russell Speechless as they know. Dr. Hamid, is there anything that you would like to add on that point?
I agree 100% with James. What we notice, even the experience of SCCA in the cases that we receive, especially from the commercial court, I feel, first of all, the privacy playing an important role, and also the flexibility. In addition to that, the support from the judicial system. For example, now the converting the enforcement, the settlement into enforcement title, that played also important role. And I can also make the fourth reason for supporting mediation, conciliation in Saudi in particular. Also the cultural aspect. I feel the culture impacting positively the mediation and conciliation. So mixing the culture with the tools, the modern, you can say, tools. So for example, in SCCA, starting from 2017, very early, maybe the first year, and even before we launched officially, we started with ICDR conducting a special program for mediation. And we saw, the professionals, especially the lawyers, they were very thirsty to attend and to get benefit of this, and also the feedback after the program, the written and the feedback from the lawyers, well-known lawyers, was great to mix these techniques, modern techniques, with the culture. I think this mix play important role, and I feel there is a bright future for mediation and conciliation in Saudi in particular, and in the region in general.
Thank you very much, Dr. Hamid. What I was proposing to do, there's one final question I was just going to put possibly to Dr. Hamid and maybe to James, and then I was just going to invite each of the panelists maybe to sum up any further thoughts in a sentence, and we'll close it down. So we'll let it run for just a little bit more than an hour. So in fact, my old university colleague, Paul Rosdell, has asked about how does ADR fit with Islam? So that's quite a big question, Dr. Hamid, for you to answer in a couple of sentences, but I'm sure you can give us a flavor.
Honestly speaking, maybe I ended my answer for the first, the previous question about, for example, conciliation, mediation. For example, in Islam or in Sharia, it's the people that are encouraged to reach a settlement. So mediation or conciliation, sulh or musalaha in Arabic, something encouraged, the people are encouraged by religion to reach a settlement and to reach, middle ground. So I feel here it's positive. And also arbitration, it has mentioned Quran and in Prophet Muhammad Sunnah. So I think what I can summarize in a sentence, it's playing a positive role to support arbitration and mediation. And because of that, what you can see, for example, Saudi is ratifying and is a party to New York Convention since more than around now 20 years or more, and now Singapore Convention, and we are very active, and our center is now within the best practices, and nothing of that, there is nothing of that is contradicting with Islam or with Sharia. It's the opposite, is encouraging all of these techniques and all of these dispute resolutions is encouraged by religion.
Thank you, Dr. James, was there anything you'd like to add?
Very briefly, I think people know that there's always been this notion of wasata or mediation, but also sulha. So where you, and even places like in Afghanistan and across the region, you've got a lot of traditional mediation. And sometimes when we've brought in international programs, so for example, 2005-06, I was training the mediators in Jordan. And interestingly, when I would come back, they would show me statistics from the newspaper saying that their mediators had, for divorce, speaking of family, that they had a 68% reconciliation rate in their family mediation. Now, I said to them, oh, that's very interesting, because I can assure you that is not the case in the West. When you show up for a divorce mediation, you leave with the divorce. But what they did was they were doing this. Now, my concern at the time was, are these mediators skilled in this very separate area, which is reconciliation and counseling and so on? And they underscored, and you have to accept it because this is what they're doing and they like. They say, listen, in Islam, we are encouraged to keep the family together, and we are encouraged to bring people together, and this is how we do it. So people will be doing what they've been doing in the way that they choose. But I think that there's also, in any of these situations, the key is having user awareness. Because if the users get what they expect and what they've been prepped to experience, whether it's arbitration or mediation, they will be thoroughly satisfied, they will be able to make informed decisions, and they'll get a quality experience. The challenge for us is to make sure that people are properly prepped, briefed, advised, and otherwise ready to use the processes appropriately, and that we deliver the process as billed, as badged. Okay, thank you very much. John, do you want to maybe kick off with a couple of, is there anything, well, it's a good opportunity for the whole of the panel to deal with anything that I've forgotten to, so if I apologize in advance for forgetting anything. John, do you want to say a couple of words to sum up any things you particularly take from all this?
I found a very interesting discussion. I think Saudi is the word unique sometimes is overused, but I think Saudi is uniquely placed for long-term construction projects to embrace a faster method of dispute resolution and maybe dispute avoidance. You know, we have the Red Sea project, we have NEOM. I looked up to remind myself earlier on today on the mega projects, and they are absolutely enormous projects there, and one doesn't want those to run into problems. So I think Saudi is a very, very well placed to lead the region and maybe even the world in terms of resolution of disputes and issues on mega projects. So I look forward with interest to the next few years.
Thank you, John, and thank you for your contribution earlier. Robert, just very briefly to wrap up.
Mute.
Unmute, Robert. Here we go. Hello, Robert. Hello, Robert. Yes.
Yeah, back again.
Is everybody there?
Yes, actually, I mean, what John just said is absolutely right, and it's be interesting to see how it develops. From my perspective, I've been very encouraged to see the way that ADR, not just arbitration, but generally, is being taken up within the region, and of course, the fact that Saudi is accelerating their ADR program and has taken great leaps and bounds over the last few years, as have some other countries. It seems to me that we are definitely moving in the right direction. I think we need to work a little bit harder on mediation. The tools are there, but the users still aren't convinced in some areas. Certainly, a lot of the people I talk to here in Dubai, their big concern, of course, is the lack of privacy, the lack of confidentiality. But there are ways to overcome this. And indeed, as we've seen, Bahrain is already finding ways to overcome it within their rules and regulations. So yes, let's move forward. I think ADR has a great future here. And if it takes the pressure off the courts, that can't be a bad thing.
Okay. Well, I'm going to ask James and Dr. Hammond in a minute just to kind of sum up. My experience is that I did a mediation last June, in fact, in Dubai. We did it for 2 days. We didn't settle, but that was under the rules, mediation rules of DIFC, LCIA. So we had a nice framework, we had a preliminary meeting. We didn't settle, but we gave it a good go, and everybody you know, behaved as they would in a mediation anywhere else. So it was really good. Now I'm just going to bowl a bit of a fastball at you, James, because I've got a couple of questions which come in from Q&A, which you may have seen from Tilal Faye. What are the 5 conflict, I think it's conflict resolution strategies in the GCC? I wasn't sure there were 5, you may be aware. And then as a supplemental from somebody else, where does the need, if any, for solutions to fit in with Islamic law? Where does that fit in with the overall picture? So over to you, James, briefly.
Thank you. I think
I didn't mean to put you on the spot, but I have.
No. I think, well, the interesting thing about the strategies, I think the key to making sure that this thing is fully realized is a combination of sustained investment of time, energy, effort, but also a real alignment. We have to have collegiality, which we've always tried to encourage between the ADR centers, between the ministries of justice. When we designed the Middle East Judicial Dialogue years ago, that was very important to bring together the Supreme Courts of the region. These things do matter, and you can see it because even in 2008 and 10, the Saudis sent to our events in Bahrain, 20 senior judges who were absolutely fully engaged, fully briefed, and turned on. When you meet the judges, and Dr. Hamid's been meeting with the judges across the Saudi region, and we've been doing it, he and I have also done it with judges in Kuwait and elsewhere, Oman. They are all very, very enthusiastic about not being obstacles to arbitration and mediation. The thing that judges will always say to Dr. Hamid or myself, and I'm sure they've told them to you, is we are here to enable the parties to do what they wish, what they set out to do, and we're not there to be obstacles. We're there to facilitate the arbitration and the mediation processes. I think that bodes very well. I think the strategy is more education, more collaboration, but in terms of getting more dispute boards and more adjudicative processes in place that both John and Robert have alluded to, and yourself, I think it will require that you work with people like Dr. Hamid and others who are the platform for bridging the providers with the public sector. Because as has been mentioned by all the speakers, there is this really intimate relationship between not just family-owned businesses, but and the larger infrastructure and resource ones, but also the government entities, whether it's PPP or what have you. So I think that the strategy is more alignment, more engagement, and more clarity and briefing of officials. Anybody who has met with any of the ministers of justice across the GCC and even places like Morocco and Jordan is aware that these are sophisticated people, also the ministers of commerce. They are always keen to facilitate, to remove barriers, to increase their rankings on matrix with the World Bank and otherwise. So everybody knows what's there. We just need to bridge a few gaps and help close the gap. And Saudi's mediation law will be similar to the Bahraini one, as will, inshallah, the others who have signed on the Singapore Convention. But Dr. Hamid, over to you.
Okay, thank you, James.
I agree with James 100% about what he mentioned. I think I can summarize that in 2 words, to make ADR systematic and sustainable. And that needs maybe a lot of tools, as I tried to draw during my presentation very quickly. For example, sometimes if someone, or at the time, someone enthusiastic to do something, if you cannot keep the momentum to make some things systematic and sustainable, it will be like a moda, and it will disappear in few years. And I remember a friend of mine in Bahrain, in BCDR, he said, Hamid, I saw a lot of ADR centers established all around the world. And I tell my colleagues, this is my colleague is saying, he asked his colleagues to stay for 3 to 5 years. If the center is survived, so they will have future, because sometimes, someone is enthusiastic to establish a center and they thought it's just kind of good place and just, a good tower, and that's it. I think what I see in reality in Saudi on the ground, it's a systematic and sustainable change, and it's part of the Saudi vision. The Saudi vision is a systematic and sustainable change in all aspects, and we are part of that. Just very quickly, and I agree with James, part of that is building the new generation. So for example, here in SCCA, we started the first Arabic moot, and the first version was between universities. This is just an example about systematic and sustainable. We started from the universities. Our target was, if we thought if we are able to attract 10 teams, we are lucky. We ended up with 39 teams. And you know, the enthusiasm from all of these students, girls and boys, was amazing, amazing. Universities from all around Saudi, from north to south, from east to west, to show you it's a systematic, and they were day and night studying UNIDROIT and UNICITRAL and SCCA rules and all of these things, and it's new for the country. So this is one of the tools: education, awareness, laws and regulations to make it systematic. For example, I remember we used to we did 2 workshops with the judges, and His Excellency the Minister, he wanted to make that systematic. So we agreed with the Ministry of Justice not to make it, sometimes some workshops. He agreed, His Excellency, to sign a contract, an MOU between SCCA and the Ministry of Justice to create a special training material to be on periodic basis, to be conducted for the related judges, to make it systematic and sustainable. So these some of the examples. Just we would like to see ADR is not a moda, it's a systematic, and there is a trend for the development of SCCA. And if you witness 2018-19 in terms of laws and regulations, in terms of education, in terms of the enforcement, in terms of the cooperation between all the these all of these things, by the end of the day, you will see it's a future. There is a future of SCCA, and we witness that in terms of number of cases, the number of big companies they are including SCCA model clause in their contracts, and the number of people they are interested. I can't say, just I would like to finalize with this information. When the Minister of Justice and their arm, the Conciliation Center, they announced they opened the door for conciliator to register for conciliation. More than 20,000 they applied. So there is big demand because everyone believes there is a great future for ADR in Saudi. So everyone wants to be part of that. And I'm happy there is a vision from the government to be within the best practices. As you can see, all our aspects, international, our rules, our roster, our advisory boards, and our board. Sorry again for I spoke more than I thought.
Dr. Hamid, thank you. Well, it remains for me to wrap this up by thanking our fantastic audience and their participation in the polls, and also in the Q&A and the chat, and also to thank our distinguished panelists. Thank you very much. A very wide-ranging set of contributions. And just finally to say that the recording will be available, I'm sure, on the respective websites of the SCCA and ArbDB chambers, and elsewhere on the usual kind of social media and pod places, your pod places. And we will also see whether we can email the recording, which we've done before actually, to the participants. So again, thank you to our audience. Without you, this would not work. And thank you to our panelists. Without you, it won't work. And may I wish you, in respect of those in the region, a very good evening, and in respect of those elsewhere, a very good afternoon. Thank you very much indeed.
Thank you.